Good day, I'm Ajayi Kemisola Ajayi, a 500 level law student at Olabisi Onabanjo University, Agoiwe, Ogun State. I am also a virtual intern at HARLEM Solicitors. Today, I'll be taking us through a short but detailed journey on the topic, the lawful interception of communications regulations in Nigeria. To start with, Section 37 of the Constitution of the Federal Republic of Nigeria, as amended, provides for the right to private and family life. It states that the privacy of citizens, their homes, correspondence, telephone conversations, and telegraphic communications is hereby guaranteed and protected. This means that communications is regarded as private and is protected by the Constitution. Hence, the unlawful interception of communication contravenes the provision of Section 37 of the Constitution. However, Section 45 of the Constitution of the Federal Republic of Nigeria provides that nothing in sections 37, 38, 39, 40, and 41 shall invalidate any law that is reasonably justifiable in a democratic society. As a result, the National Assembly has been empowered to make several laws to regulate the interception of communications in Nigeria. Some of the laws that has been enacted by the National Assembly for the regulation of the interception of communications are 1. The Nigerian Communication Act 2003, hereinafter referred to as the NCA 2003. 2. The Cyber Crimes Prohibition Prevention etc. Act 2015, hereinafter referred to as the Cyber Crimes Act. 3. The Lawful Interception of Communications Regulation 2019, hereinafter referred to as the Interception Act. 4. The Mutual Assistance in Criminal Matters Act 2019. And 5. The Terrorism Prevention Act 2011. The NCA 2003 is the principal legislation that regulates telecommunication matters in Nigeria, and it has provided for the lawful interception of communications in Nigeria by virtue of Section 147 and Section 148 subsection 1 of the Act. Also, Section 39 of the Cyber Crimes Act 2015 provides for the interception of electronic communications where there are reasonable grounds to suspect the content of such electronic communications. That is, where the content of an electronic communication is suspicious, interception will be admissible or permitted. Also, Section 38 subsection 4 states that the unlawful interception of communication is an offence and is punishable under this Act. That is, unlawful interception of communications is an offence by virtue of the Cyber Crimes Act. Moving further, Section 19 of the Mutual Assistance in Criminal Matters Act empowers an authorized agency to request the interception of telephone conversations or communication where the matter for which it is needed is criminal in nature. That is, telephone conversations or any other form of communication can be intercepted for the purpose of criminal trials. Also, Section 23 subsection 1 of the Terrorism Act empowers an authorized agency with the approval of the Attorney General of the Federation to apply for an order of the court for the interception of communications in Nigeria for the purpose of prevention of terrorist acts in the country. The Lawful Interception of Communication Regulation 2019 was enacted by the Nigerian Communication Commission, also known as the NCC. Now, Section 4 of the Interception Act provides for the lawful interception of communications, and it states that it shall be lawful for any authorized agency listed in Regulation 12 subsection 1 of these regulations to intercept any communication. Section 5 renders the unlawful interception of communications an offence that is punishable under the Act. It is to be noted that interception of communications may require a warrant or not, and the instances in which the interception of communications will require a warrant is provided for in Section 7, subsection 3, paragraph A to E. The grounds in which interception of communications will require a warrant are: 1. Where it is in the interest of national security; 2. where it is for the prevention or investigation of a crime. 3, where it is for protecting and safeguarding the economic well-being of Nigerians. 4, where it is for the purpose of public emergency or public safety. And 5, where it is in fulfillment of international mutual assistance in which agreements in which Nigeria is a party to. Where all this occurs, interception of communications will require a warrant. However, I stated earlier that there are some instances in which interception of communications in Nigeria will not require a warrant. And these instances can be found in Section 8 of the Interception Act. The instances in which interception of communications will not require a warrant are: A, where a party to the communication has approved or consented to the interception of the conversation. 2, where it is the person who was a party to the communication that intercepted such communication for reasons of threat to life and security. 3, where it is in the ordinary course of business to monitor or record such conversations. Section 16 of the Interception Act also makes it an offense for the unlawful interception of communications, and a licensee who fails to comply with the provisions of the Interception Act is liable to a fine of 5 million naira and also an additional fine of 500,000 naira for every day that the offense subsists. By subsection 2 of section 16, such a licensee may also have his license revoked for contravening with the provisions of the Act. From the above stated, it can be seen that the interception of communications can occur due to 1, protection of lives and property; 2, for the interest of national security, to safeguard the country, to prevent crime, and to prevent terrorism. In conclusion, the interception, where it is lawful, of communications in Nigeria is good and protects the country. However, the lawful interception of communications should be conducted in such a way not to deprive the citizens of their right to private and family life, which include communications. Thank you very much. For more information, please visit our site at www.harlemsolicitors.com. Thank you.